Paper. Kia ora.
Maureen Pugh.
I move that the question be now put.
Call Jan Logie.
Thank you, Mr. Chair. I would like to speak again in terms of, but with some additional information about the Minister's SOP, and to thank Labour colleague Lewis Wall for her contribution and I think creating that picture around why my SOP to add intimidating to the list of inadmissible evidence questioning is so important, and because it is about how we can create and change the culture in our courts in a way that holds the belief that we can achieve justice without traumatising people. And I think that intimidating questioning is clearly aimed at traumatising witnesses. And I don't believe that that is necessary to achieving justice. I absolutely don't believe it, and I don't believe that most New Zealanders think that witnesses should be intimidated in the docks, and that our courts should be a place where that happens. Full stop, let alone for people who have experienced violence against them in such a deeply personal way, and the impact that that has on people, and then to have to stand up in front of a room of people and expose yourself and then be intimidated through that process. That is not about justice. And I do hope members in this House will vote tonight for a compassionate justice system that believes and stands up for the rights of defendants and the dignity of victims. So I would just like to speak a little bit more again to the problem I have with the Minister's SOP, which delays the review of this Act and puts that further out, just by bringing to this House's attention some of the issues that would be considered in that review. So this is issues around whether the court should record evidence at trials of complainants in cases where it's not already pre-recorded. And this is particularly, again, important for victims of sexual violence when we have very long delays in people being able to get their cases to court, and that this process can go on for a very long time. And if there hasn't been a pre-recording, or if there's a mistrial, or people have to come back, to be able to keep holding that experience, to be able to keep it alive, to be able to recall it accurately under questioning at sometimes months, if not years down the track, is traumatic. So the review of this Act would help this Parliament consider that amendment properly. It would also be that the extending, looking at basis of admissibility of relevant evidence should be expanded to the impact of having to answer questions on the complainant, considering the impact of the questions on the complainant, especially during cross-examination, and the taking into account the distress likely to be experienced as a consequence of the questioning. And we know, again, this is very significantly linked to the issue of intimidation, but goes much wider than that, around considering how do we create court processes that give the defendant the right to a proper trial and proper consideration of evidence, but do not cause distress to a complainant. And that is not a simple thing to work out. A huge amount of work has been done on it, and clearly we haven't got there with this piece of legislation to be able to come up with solutions. But the longer this government, the Minister's SOP will extend the process of being able to come up with a solution to that even further. And it is pretty much to the heart of the problems with our court system at the moment. Also, looking at other issues that came up for the Law Commission to consider were, Mr Chair.
Call Andrew Bailey.
I move that the question be now put.
The question is that the